Hi, my name is Brenton Lucas. I'm the Speakers and Panels Chair of this year's Student Symposium. I'm honored to introduce you the moderator of our next panel, the Honorable J. Harvey Wilkinson III, a distinguished judge on the Fourth Circuit. Among his many accomplishments, Judge Wilkinson has served as a law clerk to Justice Powell, a professor here at UVA, and Deputy Assistant Attorney General in the DOJ Civil Rights Division. He's a fellow of the American Academy of Arts and Sciences, a recipient of the Thomas Jefferson Medal, and the author of several books. Please join me in giving a warm welcome to Judge Wilkinson.
Thank you, Brenton. Brenton neglected to mention he's going to be a law clerk of mine next year. I'm sure after that introduction you're going to do just fine. It's a great pleasure to welcome everybody to the Federalist Society Symposium this evening. And our topic is economic theory and civic virtue and the meaning of the Constitution. And as you know, Justice Holmes stated emphatically in his dissent in Lochner v. New York that, quote, the Constitution is not intended to embody a particular economic theory. But is it really that simple? To be sure, the Constitution does not lay out a theory in the sense that Adam Smith or John Maynard Keynes attempted to do. I also doubt that the Constitution as such is taught in many economics classes. As to economics and other areas, our founding document may be more implicit than explicit. And with regard to economic theory, it is something of a tease. And yet, it cannot be contended that the framers were unconcerned with economics. It was in part over taxation without representation that the American Revolution was fought. And the Constitution contains references to what might loosely be termed economic subjects. They are the taxing, spending, and commerce powers of Article 1, Section 8, the Contracts Clause of Article 1, Section 10, Just Compensation Clause of the Fifth Amendment, and the references to property protections in the 14th Amendment. Well, think of all these references. Are these references coherent? Do they amount to an economic theory? Superficially, at least, they seem very different. Some of the references speak to the powers of Congress. Others set prohibitions upon the states. Some seem concerned with economics in a macro sense, others in a micro sense. So is there a tie that binds these provisions, or are they simply a collection of eclectic references? And what of the Constitution's paramount commitment to self-governance? Does that suggest that the Constitution's real and true economic message is to leave management of the economy to democratic institutions and to the people themselves? Must we number among the Constitution's great silences the question of how capitalism and democracy will manage to coexist? The other topic of our panel is that of civic virtue. Let us stipulate that the framers, though far from perfect, were a virtuous generation. The irony was that a group of high-minded gentlemen planted in our founding charter the seeds of equality and democracy that in time undid the pernicious class, racial, and gender distinctions that dominated their day. But to leave it at that may overlook the grand bargain of the Constitution. That magnificent document conferred upon us two forms of liberty, both personal and democratic. But is the gift of liberty always conditioned on responsibility in the exercise of it? Is that the Constitution's true theory of civic virtue? Have present generations squandered that? or have we in fact earned the grant of freedom that the framers bequeathed us? As you can see, we have a great many questions for the panel to discuss. Our program is going to be divided into three parts. The panelists will first present brief opening statements. They're then going to join issue and discuss these matters among themselves. And finally, we want to open the floor to questions from the audience. I hope you're going to enjoy tonight's sessions. We have panelists of exceptional distinction. I look forward, as much as you do, to hearing what they have to say. Now, these opening statements are going to be about 8 minutes. As a judge, I love to pound the gavel. And we want to keep things moving. Keep your attention crisp. So in that spirit, I'm going to dispense with long introductions, as you'll find all those in your program. Our first speaker is Professor Ted White from the University of Virginia School of Law. It's a special pleasure for me to welcome an old friend. We've been friends for almost 40 years when Ted clerked for Earl Warren and I was clerking for Lewis Powell. And Ted is not only one of the premier legal historians of this generation, but of any generation. And Ted, it's a special pleasure to have you lead off our program.
Thank you, Jay. The reference to Earl Warren, the last time I attended a gathering that I would say would be that where the political temperature was comparable, I was identified as a former Warren clerk and a biographer, and the audience hissed. So thank you for refraining. The first session was an extremely interesting debate with contemporary implications, and I apologize in advance for damping down the temperature and doing some relatively straightforward historical comments. But I think the first question before us is, when we're talking about economics and civic virtue in the Constitution, what Constitution are we talking about? I'm proceeding on the assumption that what I'm calling the original Constitution, that is the period from the ratification through the Bill of Rights, the constitutional provisions that extend to 1791, should be the controlling document for our discussion. It's obviously not the controlling document for the conference generally. Others may disagree, but to the extent the inquiry is, what did the framing generation think about these attitudes? I'm going to argue, I'll just begin the argument in these remarks, that the attitudes of the framing generation were generationally distinctive. And we can't really understand the provisions of the original Constitution without filling in some of that generational distinctiveness. Now, when I'm talking about the Constitution as an economic document, what I mean is a document with implicit and explicit attitudes about political economy. The framers did not disengage economic activity from the question of how economic activity fit into the Republican government that they were creating. And so the provisions that we could call economic provisions are informed by that general consciousness about political economy and, moreover, about human economic activity. And I want to just remind you that the Constitution begins with a rather negative critique of the tendencies of human office holders that's inspired by Madison and informs the transition from the Articles of Confederation government to the Constitution. The changes that are made to the Articles are predicated on two problems that the delegates of the convention identified and Madison articulated for them with the government that existed from 1776 through the late 1780s. The first was the problem of unicameral legislatures and the tendency of unicameral legislatures to sow factionalism and demagoguery. And those problems were themselves incident upon the assumptions that the framing generation made that humans are essentially self-interested, inclined to pursue their interest, and will use positions of governmental power to do so, so that if you have no adequate checks upon the behavior of human officials, whether they are legislators or other officials, they will form factions, try to preserve and increase their interests, and that they will use their powers to make overtures to the masses generally to try to persuade them to follow their interests. So unicameral legislatures and those problems are an essential part. The other assumption, again a negative assumption, is that office holders in a government in which state power is manifest, the Articles. You remember the Articles government has very little independent power because it needs to get the approval of the states for nearly every policy that it formulates. The assumption is that the states will be parochial, that they will resist efforts on the part of the general government to appeal to the common weal, that they will be antagonistic to one another, and that this will result, and it did result for the framers, in weak government. So what I'm calling the economic provisions of the Constitution are predicated on these deep and I would say some less than sanguine assumptions. Now, the framers are not wholly pessimistic. They believe that these problems can be fixed. But they also believe that these problems are endemic. And so you need constant checks and balances. That's why they begin a federal government from scratch with an emphasis on separated powers and checks and balances to avoid the vices of unicameralism. That's why they insist that certain kinds of powers in the federal government be reserved for that government and trump, in some instances, competitive powers by the state. So if one were to make a list of the economic provisions of the original Constitution, they fall into two categories. There's the so-called private rights category, and we've heard these provisions identified before: the Contracts Clause, the Due Process Clause of the Fifth Amendment, the Just Compensation Clause of the Fifth Amendment. These are all provisions that are restraining unicameral legislatures from assaulting private rights of property and contract. Then we have what I'm calling the federalism provisions. These are provisions designed to grant certain kinds of economic powers to the federal government and at the same time to take them away from the states. And then finally, there is the economic provisions of which there are more than any other type in the Constitution. And those are the provisions involving slavery. And we should not forget that the Constitution is a strong commitment to the principle of private property in slaves and the distinction between slaves and other persons. So this is a document, for all of its aspirational qualities and for all the ways in which we revere it, it is also a decidedly pro-slavery document. I'm going to largely stop there. I'll conclude with one other discussion. We don't see any provisions in the Constitution that are expressly concerned with virtue, and we don't see any provisions in the Constitution that announce one or another economic theory. So I think in order to get at those issues more fully, we need to go back and look at the generational attitudes themselves and ask ourselves, what did the framers mean by virtue? How did they assume that virtue could be infiltrated into government? And was virtue a function of economic activity, or was it a function of office? Was it a function of society? Was it a function of something else? Was there a necessary relationship between economic activity and virtue, or was in fact there a contradistinction between them? And with respect to what kind of attitude toward markets the Constitution have, we have no signal in the provisions there either. We have glosses that we might read in favor of free markets or in favor of regulation. But in fact, the historical context of the framing generation is largely one of promotional and regulatory activity on the part of the government rather than free markets. So I want to just close by cautioning us against anachronism in trying to read back into these provisions. And I'll have plenty more to say in the discussion. Thank you very much.
Our next speaker is Renee Lerner, a professor at the George Washington University Law School. I'm tempted to read her introduction because it's so impressive, but I promised I would not do so. But there are some folks you've heard a lot about before you ever meet them, and Professor Lerner has been one of those. So when you finally get to meet them, it's a real treat, and it's absolutely great to have you on the program, Professor. Come on up.
Thank you, Judge Wilkinson. Did the framers have an economic theory in mind when they wrote and ratified the U.S. Constitution? Some say the principal framers did not have a common, cohesive set of views on economics. Others consider the question to be irrelevant. Some say society and constitutional interpretation have moved on. So what the framers thought, or if they embedded economic views in the Constitution, has about as much relevance today as a typewriter. Others believe that the framers may have had common understandings about economics, but largely left them out of the Constitution, except perhaps in odd bits like the Contracts Clause or the Takings Clause. I believe that the principal framers did share a set of economic views, although of course they did not agree on all economic questions. I also believe that these economic views permeate the Constitution and are not manifest only in odd clauses. Many structural features of the Constitution are designed to further desirable economic ends as the framers saw them. What then was the content of the framers' economic beliefs, and where did they come from? I argue that in fact these beliefs were widely shared throughout Europe, although events in America helped to reinforce them. Historians and students of philosophy have long explored the political thought of the Enlightenment, the contractual theories of Locke, the checks and balances of Montesquieu, and so forth. This political thought, however, went hand in hand with Enlightenment economic thought. To understand Enlightenment economic thought, that thought that the framers shared with many in Europe, it is necessary to understand something about the workings of the old regime. Guilds, monopolies, and mercantilism characterized that regime. The guilds formed an elaborate regulatory apparatus. To get a dress made in France, for example, one had to buy cloth from the draper and accessories or ornaments from the mercer and take them all to the tailor, who then cut them according to the rules of his guild. The tailor was forbidden to sell or stock cloth. If these resemble union work rules today, that's not an accident. Governments sold monopolies or patents, as they were known, to manufacture, exportation, or importation of coal, soap, starch, iron, leather, books, wine, fruit, in short, on almost everything imaginable to raise revenue. Colonial Americans resented English mercantilism in the form of the Navigation Acts, which required colonists to export certain goods only to England or its colonies, and to conduct their trade entirely on English or colonial vessels. In the first half of the 18th century, these old economic ideas dominated thought and policy throughout Europe. commerce was viewed as a kind of warfare. Mercantilism was widespread. But gradually, in the second half of the 18th century, different economic ideas took hold. Thinkers praised free trade as leading to economic growth for all participants. Trade was seen less and less as a zero-sum game. Rent-seeking and monopolies came under increasing attack. Leading the charge, of course, was Adam Smith at the University of Edinburgh. Adam Smith's arguments in favor of free trade are well known, and in The Wealth of Nations, published in 1776, he called monopolies the great enemy of good management. Other thinkers also praised free trade and condemned monopolies, even before publication of The Wealth of Nations. Montesquieu, in a 1768 edition of Spirit of the Laws, discussed how trade brought prosperity to all participants, and he declared, "Peace is the natural effect of trade." Fortunately for the New Republic, the two most important founders least affected by Smith's thought were not at the convention in Philadelphia. John Adams was a Malthusian pessimist, Thomas Jefferson an idealistic agrarian, and both were busy in Europe during the summer of 1787. Proof, if anything could be, that God was looking out for America. Benjamin Franklin, another agrarian, was there, but was in his dotage. At center stage in Philadelphia were those who had studied The Wealth of Nations carefully and almost unconsciously quoted from it, including James Madison and Alexander Hamilton. Most public men in America at the time had at least a passing familiarity with the book, so great was its popularity. If then the most important framers in Philadelphia largely shared the economic views of prominent Enlightenment thinkers such as Adam Smith and Montesquieu, why do we see so few direct traces in the Constitution? To be sure, there are the Contracts Clause and the Takings Clause, evidence of the importance to the framers of upholding contracts and protecting private property from government interference. I would argue, however, that many of the broad principles of Enlightenment economics, such as promoting free trade and preventing monopolies and rent-seeking, would be difficult to enact directly. One could imagine a variety of exceptions under different circumstances that would make it hard to draft a general rule. In the area of patents for intellectual property, the framers actually sanctioned monopolies in the Constitution itself, though not without controversy. So we therefore, for the most part, should not expect to find direct enactment of these ideas. That being said, the framers crafted numerous parts of the Constitution to further these principles indirectly, if not directly. And I'm going to discuss two of them now: the interstate and foreign commerce clauses and the interstate and alien diversity clauses. Now, there are others. For example, the elaborate procedures of bicameralism and presentment for enacting bills, and constitutional limitations on legislative power, but alas, Judge Wilkinson will crack the whip and prevent me from discussing those latter two, but hopefully we can during discussion. The clauses giving Congress the power to regulate interstate and foreign commerce were intended to prevent the states from restricting trade. This can be hard to remember in our post-New Deal era, when the clause is used to justify Congress regulating every conceivable thing, including someone growing marijuana for her own consumption. The concern with the states restricting trade was not merely hypothetical. The states were slapping tolls and tariffs on each other and attempting to do the same with foreign commerce, as well as creating monopolies that restricted trade. The case of Gibbons versus Ogden in 1824 perfectly illustrates the way the Commerce Clause was designed to operate. The state of New York, in very unenlightened, old regime fashion, granted a monopoly to several investors on steamship travel in New York waters. Congress had enacted its own non-monopoly licensing system governing ships. In Gibbons versus Ogden, the U.S. Supreme Court struck down New York's monopoly, citing Congress's power under the Commerce Clause. In one blow, therefore, the U.S. Supreme Court simultaneously struck down one of the most despised features of the old economic regime, the monopoly, and furthered one of the Enlightenment economists' chief goals, free trade. The interstate and alien diversity clauses concerning federal jurisdiction found in Article 3 were also based on a desire to increase trade. The framers realized that trade could not flourish if out-of-state or foreign merchants had the deck stacked against them in state courts. In the Virginia Ratifying Convention in June of 1788 in Richmond, James Madison argued in favor of federal diversity jurisdiction, saying, "We well know, sir, that foreigners cannot get justice done them in these state courts, and that has prevented many wealthy gentlemen from trading or residing among us." The same difficulty applied to out-of-state merchants. And there is, incidentally, no doubt that the issue of bias in state courts affects interstate and foreign commerce today. U.S. and foreign corporations have made explicit statements about that, and this suggests the problems with many limitations on diversity jurisdiction. Well, I've left something out of the account, and that is virtue. How does virtue fit into all this? Actually, it's quite central, and I believe that Professor Lund will address this in more detail. But I suggest that tonight you curl up with your handy copy of Adam Smith's Theory of Moral Sentiments and Montesquieu's Spirit of the Laws, and reflect on the virtues promoted by private commerce and the evils of rent-seeking. Feel free to apply those latter reflections to, say, AIG and the Wisconsin public sector unions. You might think, too, of the virtues that ought to be possessed by members of Congress, the president, and judges to enable them to adhere to the provisions of the Constitution, and not least, the virtue of the electorate, that is us. You could have an enlightened evening. Thank you.
Our third speaker is Professor Jim Ely of Vanderbilt School of Law. Jim and I have known each other since the 1970s when we had the same mentor, Professor Ed Younger, at the University of Virginia History Department. We were engaged in a study of Virginia governors at the time, and I thought, Jim, when I was reading your biography, just how proud our old mentor, Ed Younger, would be of everything that you have accomplished, which has been immense. And come on up and give us your views on these topics.
Thank you, Jay. It's a pleasure to be here and offer you my thoughts, if perhaps somewhat more hurried than I might like. And I certainly would be happy to enlarge any of my ideas during a question-and-answer session. I'd like to start by asking you a couple of questions. Does the Constitution simply establish a framework for the resolution of political disputes? Is the Constitution neutral with respect to questions of political economy? In his Lochner dissent, Justice Holmes seems to have famously suggested that such was the case. Filled with quotable quips, the Holmes dissent is frequently invoked by scholars as if it contained Delphic wisdom. Nevertheless, this dissent is not without problems. Like the answers of the legendary oracle at Delphi, the opinion is maddeningly ambiguous. Yet Holmes' central premise, that the Constitution does not endorse any particular economic theory, seems clear, and that's what I would like to explore with you. In common with other remarks in the Lochner dissent, this point is more asserted than demonstrated. And there is, I think, a threshold question, one that's already been alluded to by earlier speakers. Is Holmes referring to the United States Constitution or to some theory of what constitutions should contain? Remember, his comment is, a constitution is not intended to embody a particular economic theory. Now, constitutions can serve different purposes in different societies. And even a cursory glance at constitutions in other countries will suggest that they do pretty clearly seem to advance particular economic or social agendas. Moreover, Holmes has somewhat curiously framed the debate by setting up polar opposites. This is arguably a false dichotomy. In fact, the United States has never pursued a strict laissez-faire policy. And even as he wrote, lawmakers were enacting a host of economic regulations. His reference to paternalism and the organic relation of the citizen to the state, although somewhat opaque, likely points toward the attacks on individualism and claims of individual economic right that characterized the progressive era. Of course, Holmes could be partly correct and partly wrong. The fact that the Constitution does not affirm either paternalism or laissez-faire fails to establish the broader proposition that the Constitution has no relevance for economic policy. Can we seriously believe that the framers had no economic program in mind? It is hard to square the agnostic position of Holmes with the expressed views of leading framers, or with numerous provisions of the Constitution and Bill of Rights. In fact, let me remind you that the movement to establish a new government in 1787 was fueled in large part by the desire for a central authority capable of protecting private property and contractual rights, encouraging trade, restoring public credit, and defending American interests abroad. We must bear in mind that the tenets of constitutional thought in the late 18th century put enormous stress on protection of private property. That was, of course, inherited from England and exemplified by the writings of John Locke. It also bears emphasis that leading delegates to the Philadelphia Convention employed Lockean language and explicitly linked individual rights and the right to private property. As Stuart Brucey has aptly noted, perhaps the most important value of the founding fathers of the American constitutional period was their belief in the necessity of securing property rights. Of course, I would not submit that the framers were guided solely by constitutional theories, no matter how prevalent at their time. Economic developments in the late colonial period, as Renee has already pointed out, undermined the earlier system of mercantilism with its focus on guilds, price controls, public markets, and regulations. The colonists, by the late 18th century, were gravitating, however slowly and imperfectly, toward a free market economy based on private contracting. Take, for example, right here in Virginia, historian William Nelson has asserted that as early as the 17th century in Virginia, the hallmark doctrine of market capitalism, that individuals should be free to enter into contracts which courts would then enforce, was firmly in place. Moreover, a land law was similarly modified in ways to encourage a freedom of alienation and thus participation in the market economy. And I hardly need remind you that interest in land speculation was widespread, including many members of the Philadelphia Convention. Such luminaries as George Washington and James Wilson were actively involved in land speculation. Obviously, the framers were familiar with these movements toward a market economy and almost certainly approved of them. Not surprisingly, then, many provisions of the Constitution and Bill of Rights pertain to property and economic interests. I won't rehash any. They've already been alluded already, and time is fleeting. I suggest to you that it's hard to quarrel with the conclusion of Charles A. Beard, once the enfant terrible of the historical profession, who observed in 1913, the Constitution was essentially an economic document based on the concept that the fundamental private rights of property are interior to government and morally beyond the reach of popular majorities. The major part of the members of the convention are on record as recognizing the claim of property to a special and defensive position in the Constitution. I submit that even a cursory glance that the Constitution drafting process lends support to Beard and leaves one to ponder what was Holmes thinking. Clearly, the Constitution was intended to secure property and contractual rights, and to that extent embodied an economic policy that the new government was not free to abridge. But, and now my time is running short and I want to honor our commitment to being brief, if I've argued here that Holmes has overstated the notion that the contract was neutral with respect to economic matters, he may be on firmer ground when he suggests that it does not endorse either paternalism or laissez faire. Clearly, Holmes is correct that the Constitution does not mandate the modern welfare state. Despite efforts of some scholars to argue to the contrary, I must say that I think that point is pretty clear to my mind. The relationship between the Constitution and theories of laissez-faire, to which Renee has already alluded, is a bit more difficult to unpack. Certainly leading members of the founding generation were well aware of the work of Adam Smith and were in fact impressed with his work. But Smith was not cited during the Philadelphia Convention and was rarely mentioned during the ratification debates. This does not rule out Smith's possible indirect influence, but such an influence would be difficult to chart, I fear, at this distance. Moreover, The Wealth of Nations covered many topics, and one cannot assume it was read only for its laissez-faire outlook. Lastly, as I think Ted White has already pointed out, many members of the Philadelphia Convention, Alexander Hamilton notably, were in fact very interested in having government promote enterprise. It was not a hands-off policy that Hamilton pursued, and so while I think Hamilton envisioned the enterprise would largely be in private hands, he did not rule out government-private partnerships. In short, I submit that the Holmes dissent in Lochner offers a misleading account of the relationship between the Constitution and the political economy. Even if the Constitution does not endorse particular theories, it assigns a high value to property and contractual rights. I argued that the framers anticipated a substantially free market resting on private property. Holmes lost track of this insight. He was better at predicting future constitutional developments, perhaps, than as a student of the original Constitution. He anticipated the advent of New Deal jurisprudence, about which Ted has written very perceptively, but he did not, I suggest, accurately present the views of the framers. Thank you.
I can tell we're going to have a great discussion after these speeches. Our fourth speaker tonight is Professor Nelson Lund of George Mason University School of Law. I have to share with you another personal note. Both of my children went to, one of them went to the University of Virginia School of Law, my daughter, and my son went to George Mason. And to be neutral, each of the kids gave each law school absolutely rave reviews. And my son found George Mason to be a very, very exciting place. And Professor Lund was one of those who has, through the years, helped make it so. He's one of the country's most distinguished academics. And he has a fresh and original and very principled point of view. Nelson, it's great to have you here.
Thank you very much. It's an honor to be here. I'm going to take a little bit different approach to the subject than the previous panelists. And I want to begin by pointing out that economic theory applies to many things besides the marketplace. It also applies to the government itself. Whatever the framers' views on private property and free enterprise, they certainly had an economic theory of government. That theory was summarized by Madison in a famous passage in Federalist number 51. Here's what he said: in framing a government which is to be administered by men over men, the great difficulty lies in this. You must first enable the government to control the governed, and in the next place oblige it to control itself. And how can government be obliged to control itself? Again, Madison offered a succinct theoretical answer, which was, ambition must be made to counteract ambition. We're all familiar with the practical scheme based on that theory. For the most part, the key is to make each official and each institution dependent on others. Enacting a law, for example, requires the agreement of the House and Senate, and usually the President as well. The President takes many actions by himself, but almost all of them require either congressional authorization or congressional appropriations, or both. And all of these officials are dependent on elections by the people for their continuance in office. But there's one institution in which the framers took almost the opposite approach. That's the judiciary. In the Federalist, Hamilton argued that this department of government should be insulated as much as possible from dependence on the President, the Congress, or even the people themselves. Now, one objection raised by the anti-Federalists was that the power of judicial review, which they assumed would be in the Constitution, was in the Constitution, together with life tenure, could lead to judicial tyranny. And there was one particularly worrisome objection, which Hamilton described as follows. The power of construing the laws according to the spirit of the Constitution will enable that court to mold them into whatever shape it may think proper, especially as its decisions will not be in any manner subject to the revision or correction of the legislative body. As we now know, this objection from the anti-Federalists was not exactly a paranoid fantasy. What was Hamilton's response? It essentially boiled down to this. Somebody has to have the final word on what the Constitution means, and the judiciary is the least dangerous place to put that power. Now, one reason for regarding the judiciary as the least dangerous branch was structural. The judges would control neither the sword nor the purse, and if they did get out of control, there would always be the remedy of impeachment. Unfortunately, as we've seen, that leaves a lot of room for judges to make up whatever constitution they like, as long as they don't push things far enough to get themselves impeached. And of course, even that remedy is not available when judges ignore the law by permitting Congress itself to exercise unconstitutional powers. But Hamilton also suggested another answer to the objection against judicial independence. He assumed that judges would have much more civic virtue than other politicians. Rather than relying on ambition to counteract ambition, he emphasized that a special kind of person should be chosen to fill judicial offices. What kind of people would these be? First, they had to have engaged in what he called long and laborious study of legal precedents. They would also have the kind of integrity and devotion to law that would render them deeply self-effacing and indifferent to popular acclaim. They'd be old people without the youthful fire of ambition and without the hope or expectation of using their life-tenured offices as a springboard to higher things. Hamilton, of course, didn't spell all of this out in detail because he didn't have to. English common law judges had spent hundreds of years developing a culture in which these qualities could flourish. They had done it largely through extolling and exercising the judicial virtues of modesty, self-restraint, studiousness, and caution. Not perfectly, of course, but well enough that the founding generation could easily believe that people with the requisite integrity and legal learning could be found, and that they could be trusted to conform with the traditional ideals of judicial virtue. These ideals have not been lost. Unfortunately, they now seem to appear most prominently in confirmation hearings, where every nominee, Republican or Democrat, describes himself or herself as exactly the kind of person that Hamilton called to mind. They all just want to be humble servants of the law. They have no personal or political agendas of any kind. Nothing thrills them like the study of mind-numbing precedents. And they aspire to nothing higher than the simple duty of deciding each case correctly according to the Constitution or the applicable law. Well, once these Supreme Court nominees get confirmed, we often start to see a different picture, one you're all familiar with. Now they're big shots. treated as gods by the legal profession and as A-list celebrities by everybody else. That might be harmless, but the cult of personality also shows up in their judicial work. Nearly all of the justices are manifestly consumed with improving the law by moving it in a direction that they personally favor. They frequently think it's more important to remain consistent with their own prior statements, even their dissenting statements, than to follow the actual precedents of the court. At oral argument, they hammer the advocates with questions that aren't genuine questions because they already know the answers. The justices are often just debating among themselves, with the hapless lawyers serving as props or surrogates or just victims of judicial bullying. The court's opinions tend to read a lot more like briefs than like candid explanations of the reasons for the decision, and dissenting opinions even more so. And perhaps most strikingly, judicial opinions now contain extravagant rhetoric that is manifestly designed to catch the attention of the media and the editors of casebooks. Why would that be? Because these journalists and law professors determine whether individual justices are seen as being influential. And that word, influential, has become almost a synonym for being a successful justice. So how did we get to the point where judges no longer even look like the modest and humble servants of the law that Hamilton described and that nominees always say that they want to be? There are a lot of reasons, and the biggest ones are probably beyond anyone's control. At the margins, however, I think there are incentives operating to encourage the wrong kind of ambition in the justices, and Congress could change some of those incentives. Here are 4 suggestions, which I've written about with my colleague Craig Lerner. First, Congress could require that all Supreme Court opinions, majority, concurring, or dissenting, be issued anonymously, just like the per curiams that we still sometimes see. Second, Congress could limit the discretionary nature of the court's docket by requiring that at least half of the cases they hear be on things other than flag burning, nude dancing, campaign finance, abortion, and so on, but instead be cases recommended to them by the circuit courts. Third, Congress could take away their personal law clerk staffs and relocate the research function of the clerks in the office of the court's librarian. Fourth, Congress could bring back circuit riding and give the justices a little taste of what it means to be a real judge. By which I mean someone who is actually expected to follow the law, not make it up, and who can be reversed on appeal. None of this will solve every problem, and there's no reason to think that Congress will do any of it. But it might actually have some salutary effects, unlike the kabuki dramas that senators conduct during confirmation hearings. Thank you.
Well, let me start the ball rolling by asking a question or two. And Renee, I'd like to start with asking you and Jim something. You seem to me the most, not vocal, but most receptive to the idea that the Constitution did enact an economic theory of sorts, with your citation to Charles Beard, who took that position, and your references, Renee, to Adam Smith. And I'm kind of interested to know where Charles Beard and Adam Smith lead us in today's world. And if we grant that they were influential, and let's just take Adam Smith, for example, do his views against mercantilism and guilds and the rest suggest to you, Renee, that courts ought to be striking down in the name of a free market or free trade all kinds of licensing schemes as barriers to entry? Should we do away with a bar exam as a Well, look, folks, you'd probably make Adam Smith very happy. But do our license, just from a standpoint of the bench, where are you taking us with this stuff? Should we go after, in the name of, should we raise the flag of Adam Smith and go after licensing for accountants and realtors and physicians and lawyers? And is that where Adam Smith would want judges to go, or the framers who were so devoted to him? Is that where they want judges to go?
I would say that Madison himself actually was not necessarily opposed to all restrictions on trade. Madison himself seemed to want to almost arrest development economically at the commercial stage. The Enlightenment sort of presupposed various stages that societies went through, hunter-gatherer and so forth, agriculture, commerce, and finally manufacturing. And Madison himself, I think, was concerned about that last stage of manufacturing. And so he himself, I think, under certain circumstances, would have favored restrictions of trade, almost to force other countries to open up their markets. He had the idea that if we restricted trade with England in certain respects, that England might then open up its markets, which would be an advantage to America. So short-term restrictions with the long-term goal of freer trade.
But let me follow up, and Jim, I want you to get into this too. But can either of you all give me an example of a law, state or federal, that's on the books today that you think we as judges would be most justified in striking down in the name of economic freedom, or in the name of free trade? Just give me a modern day example of something that we ought to take a hatchet to.
Well, I think, for example, restrictions on diversity jurisdiction might be something. Now, some of them were judicially created, but it seems that certain restrictions on allowing federal jurisdiction does create problems for interstate trade and foreign trade as well. So something along those lines, I think.
Jim?
I would suggest that courts might profitably look very closely at entry barriers of various types. You mentioned licensing. Of course, certain learned professions had long had licensing requirements of one form or another, law and medicine to mention two, but it spread rather beyond that. I recently was reading about some states that required to pass an exam before you could enter the business of floral arranging. Now, that strikes me as an ordinary calling. I'm not sure it requires specialized skill or the laborious study of mind-numbing precedents. And it strikes me as, frankly, a protectionist device. I think entry barriers are something that courts could very appropriately take a very close look at. And let me mention, historically, one opinion, New State Ice. I would argue the New State Ice was correctly decided, notwithstanding the Brandeis dissent, that in fact you had a naked entry barrier trying to keep competitors out of an ordinary business, the ice business. Let me also, if I can, just respond to your comment about Charles Beard. Of course, Charles Beard was one of those historians closely identified with the progressive movement in the early years of the 20th century. I quoted from his most famous work, although he was pretty prolific, his most famous work in which he basically intended the book as a slam against the Constitution of the United States and against the people who drafted it, and famously arguing, of course, that the framers had personal economic objectives, motives, and that he got all off on the question of who held bonds and who was going to benefit from funding the public debt. Now, some historians have pretty much ventilated, I think, Beard's findings in that regard, and that's not what detained my interest. What caught my interest was that Beard, who's writing a book critical of what he sees as property-conscious constitutionalism, nonetheless, because I think he, by his own lights, he's an honest historian, has to come to the conclusion that the framers were very concerned about property and contractual rights. Now, I thought that that was, to my mind, fairly persuasive testimony from a historian that we generally associate with being in another camp.
Nelson, you had a comment you want to enter in?
I just wanted to offer one candidate for a law that might be struck down by judges as unconstitutional, and that would be Obamacare.
I actually was going to mention too, of course, the entire Commerce Clause jurisprudence has gone off the rails in a lot of respects, and of course the complete lack of attention to enumerated powers, to the point where there was an interesting exchange in October of 2009 between a reporter and then Speaker of the House, Nancy Pelosi, where the reporter said, Madam Speaker, can you tell me exactly where in the Constitution is the power to require individuals to buy health insurance? And her response was, are you serious? Are you serious? And then she quickly turned to another question. Her spokesman then helpfully clarified the Speaker's response by saying to the reporter, that is not a serious question. That is not a serious question. There's a certain stylistic similarity between the Speaker and her spokesman.
Let's pick up on what you and Nelson have said. And I don't want to get into health care, obviously, but let's take it. That's all right. They want to bypass us. But as a general matter here, Nelson and Renee, if we take a big whack, it's just speaking generally, at the commerce power, the test for invalidation, the third prong of the Lopez test is whether something has a substantial economic effect. And that's just a loose and kind of elastic sort of a criterion that's just going to be, is it not, in the eye of the beholder of the individual judge. And we have a single judge or a panel of three judges sort of sitting in judgment over the work of the entire Congress of the United States, and this at a time when the economy is becoming more integrated and when intrastate activity can be integrally bound with the national economy as a whole. And if we do a job on the Commerce Clause, are we risking balkanizing our country into separate and discrete and insular economic units at a time when we're facing unprecedented challenges from global trade and from other nations? So there are costs to doing this. Is this, Nelson and Renee, is this really the direction that you want us to go in the name of some economic theory of the Constitution? What are we to do with this? Nelson?
In my view, the reason for striking down the health care law is not so much economic as it is legal. It's the Constitution, not some decision by some judges, but the Constitution that's inconsistent with this law, and you don't need an economic theory to strike it down, but I think it is helpful to have some understanding of the basic principles with which the framers were familiar and with which they sympathized in order to help you see why they couldn't possibly have meant the Commerce Clause of the Constitution to authorize something like the individual mandate that's in this health care law.
I want to jump in at this point. I think the discussion so far might be confusing two issues. The first issue is whether we can extract from the Constitution, either in its original form or over its course, something like a coherent, unified economic theory. The discussion began with the idea that Holmes's claim that there is no economic theory was potentially flawed, and all of us have pointed out some evidence, historical evidence, that at least the framers had certain economic attitudes that represented themselves in certain kinds of commitments. But the problem is that although those attitudes might be reflected in individual provisions, the Contracts Clause is certainly a robust protection for contractual obligations against state interference. It says that explicitly. But that doesn't solve two additional problems. The first is, can we extrapolate from that finding, that is, once we find that there's a historical meaning to a particular provision, can we extrapolate that to resolve a quite different case in the present? I mean, if we had the identical case from which a Marshall Court decision upheld the Contracts Clause, we had the identical facts of the case, we wouldn't have a problem, but of course we don't. And so the first question is that we have cases that are different cases, and we have to do a certain degree of historical translation. And then the second question, of course, is what do you rely upon? In Commerce Clause jurisprudence, do you go back and look at the original conception of the Commerce Clause, which is obviously a very limited reach? We don't even get a relatively latitudinarian conception of the Commerce Clause until Gibbons versus Ogden. So we have quite minimalist conception of what commerce means and what the federal government can do. But then after that, we have over a century of Commerce Clause jurisprudence. And so when we think about health care, we don't just think about it in the background of what the framers said about commerce. We think about it in terms of Gonzalez versus Reich and a whole line of judicial glosses. So we need to resolve what we're going to prioritize. So I think there's been a tendency so far in the discussion to sort of leap from some historical observations, discrete historical observations about the framing period to what I think the current court ought to do in contemporary cases.
One thing I'd kind of like to do, if I'm able to, is stir up a little disagreement between Renee and Jim and Nelson. And Renee, I understand you, in the name of protection of trade and commercial values and protection of out-of-state and multi-state companies, for example, that you thought one thing we might want to do is expand diversity jurisdiction within the federal courts. Well, what does that do to state control over state law, and doesn't that conflict with the attachment of a great many conservatives to the 10th Amendment and to the control of state judiciaries over their own law? Isn't there a real tension between what we're advocating on the one hand, which is a 10th Amendment break upon the commerce power, and then on the other hand, we're advocating expanding diversity jurisdiction, which seems to me to undercut 10th Amendment values? I mean, how do we resolve that, Nelson?
I guess it's not entirely clear to me exactly what the problem is. Either things are constitutional or they're not constitutional. And so I'm just having trouble seeing exactly what problem you're pointing to.
Well, certainly the tension was recognized at the framing period. People were concerned about federal diversity jurisdiction, and they were concerned about the effects on states and so forth, and the sovereignty of states. But the deal was made that yes, federal courts were going to have diversity jurisdiction, and the reason was because of their bias against out-of-state and foreign litigants. And that's why Madison had to make the arguments he did, and he was ultimately successful in the sense that the Virginia delegation the Virginia ratifying convention did vote to ratify the Constitution. So that's the deal that was made.
Okay.
I could add one more thing on the diversity point, which is not something I raised or have any really strong feelings about. But Hamilton, in the Federalist Papers, says that the diversity provisions of Article 3 are among the most important provisions in the Constitution because without them, the Privileges and Immunities Clause of Article 4 won't be enforceable, and that provision is what holds the Union together. So to the extent that curtailing diversity jurisdiction inhibits the ability of the Privileges and Immunities Clause of Article 4 to operate properly, then that's a problem. I don't know that there's any particular reason to think that Privileges and Immunities Clause violations are the biggest problem facing us today, but that may be the result of the success of the Constitution rather than being a problem that needs to be fixed.
Ted, you had a long experience in studying the Supreme Court, and I'm wondering what you thought of Nelson's recommendations to induce a greater culture of civic virtue on the part of the justices. Would you like to see some of them riding circuit, and would you like to see per curiam opinions be the order of the day, and would you like to see the personal elbow clerks of the justices pooled into a central staff? What, in light of your vast knowledge of the court and the way it operates, I was wondering what you thought of, because Nelson came forward with some very specific suggestions to induce a greater degree of modesty and humility on the part of those sitting on the high bench.
I would call Nelson's suggestions pre-modern in two respects. First of all, in some ways, it would be restoring an atmosphere of the court that actually went back before the Marshall Court. The Marshall Court abandoned seriatim opinions and per curiam opinions. Of course, the Marshall Court continued circuit riding. But also pre-modern in the sense that as it is a tenet of a modernist consciousness that we presume that history is a process of qualitative change, and there's sometimes progress. That there's incremental changes, and in many respects we think of them as progressive. But you could hold a different view of history. You could hold a view of history that was the view held by the framing generation, which is that history is a deterministic series of cycles. And the cycles are birth, maturity, and decay, and the cycles apply to nations as well, and governments as well as individuals. So when we are taking Nelson's suggestions and thinking of restoring them, just what are we doing? Are we returning to a simpler, more virtuous era, which I take it as a kind of a coding to Nelson's remarks, or are we just going back to a more benighted period where justices were deprived of the capacity of law clerks? I can't. I mean, there are a lot of contemporary decisions that I think one could attack and show that historically and analytically they were flawed, and you wouldn't want to necessarily overrule them. Erie versus Tompkins is one, Caroline Products is another. And in this case, I think that many justices it would be nice to see some of the current justices on the court having to do some circuit riding, particularly on horseback. And it would be nice to see the justices actually have to write their own opinions from time to time. But it's a little too late, I fear.
Nelson, the Supreme Court's a bit of an opaque institution to begin with, and if you're going to hide from us exactly which Supreme Court justice authored an opinion, isn't that going to make them less accountable and less transparent? Maybe part of the reason the justices put as much effort into the opinions as they do and work over them as hard as they do is because they have their name attached to them. I think all of us in school, when we written a bad paper, would have loved to hand it into the professor per curiam. And so, but I'm wondering whether we're making things less accountable by this step and making the court just sloppier in its work habits because nobody's called to account for anything. I mean, it's like if we went to Congress and said, well, let's do away with roll call votes, because we don't want, goodness knows, we don't want the name of a congressman attached to a vote on this controversial measure or another. So why isn't Ted's point right, that we're just going backwards into some pre-modernist view of the court? Could you respond to that?
Well, first, I want to accept the pre-modern characterization. I prefer reactionary. That would be better. But I think we have to distinguish two different criticisms of my proposals, especially on anonymous opinions. One is it'll make the court less accountable. You can't make the court less accountable than it already is. It's accountable to nobody. So I don't think that is a very telling objection. The other objection is that forcing them to be anonymous in their opinions will make them sloppy, lazy, more irresponsible than they are now in the opinions they write. That's a more serious objection. It's kind of an empirical question, but I think you can make a reasonable argument that that will not happen. And part of the analysis that you need to do is to clearly distinguish between Supreme Court justices and judges on the lower courts. Signed opinions are a very good motivator for judges on the lower courts, because most of the cases they deal with are really boring.
Thank you.
They don't get any glory from you doing a good job. It's a lot easier to think of things that are more fun than dealing with those cases. So as a motivator for the judges to do a good job, I think that is very important in the lower court. The Supreme Court has such enormous control over its own docket, and the cases themselves, because they're picked, because they're interesting and important, are naturally going to attract serious attention from the kind of judges that you hope would be appointed to the court. That I think the idea that they'll get sloppy or sloppier than they already are, and lazy and so on, is a much less compelling point here. I should add that if all of Craig Lerner's and my proposed reforms were adopted, we might get a different kind of person on the Supreme Court, and they might stay there a lot less long. So they wouldn't have clerks doing their work. When they weren't up to doing the job, they might be more likely to leave. And presidents would have an incentive to put people on the Supreme Court who are outstanding for their legal ability rather than for some of the other qualities that sometimes go into Supreme Court nominations.
Thank you.
Can I just say something?
No, I really want to open the floor up to questions because they haven't had a chance at this point. Can you make a real brief comment?
Well, I just want to quote a little bit from a letter from Jefferson to William Johnson, complaining about the fact that on the Marshall Court, many opinions were delivered as the opinion of the court without having any idea how many judges signed on to the opinion because of the phenomenon of silent acquiescence. Jefferson said to Johnson, "The practice is certainly convenient for the lazy, the modest, and the incompetent." So I'm a little less sanguine once again about restoring it.
All right, I think we need to have some questions from the audience. Yes, sir. All right, what's your question?
I'm sorry. So my question being is that massive change kind of a problem moving forward with your theory?
All right, anybody want to take that? Renee, go ahead.
The framers, as you're suggesting, actually had different views on that, right? So Hamilton, of course, much more favoring manufacturing. Hamilton also had a far more sophisticated understanding of public finance than Madison did. But I think Yes, certainly. In modern economic theory, we do have a more sophisticated understanding of a lot of areas than Madison had. I'm not sure about Hamilton. Okay, Hamilton, one of the greatest economic thinkers of his day, or perhaps any day. But in any event, and so I'm not sure that there's. I guess you're sort of saying if something comes along that completely sort of disproves Smith's trust in the private market or the value of free trade or something like that. It hasn't happened yet, though, right? So even though Hamilton and we now today have more sophisticated understanding of public finance, for example, I'm not sure that undermines the hostility, I think which is embedded in the Constitution to restrictions on trade in certain respects and guilds and monopolies and those kinds of things.
All right, let's go to you, sir.
Sam Urelli from Santa Clara University. Your discussion of changing diversity jurisdiction and potential balkanization, and also the low number of Supreme Court cases each year, brings to mind something we as law students see all the time, which is the enormous number of circuit splits on various large and small issues that may or may not ever get addressed by the Supreme Court. And I have to wonder what the panelists think about how that interacts with things. Does this call for more unifying of jurisdiction of things like patents with the Federal Circuit, or does it call for less and some sort of change in procedure with how the Supreme Court takes on these circuit splits?
Anybody want to answer that?
Give it a shot to part of it. One of the proposals that Craig Lerner and I have made will address part of that problem. There's a provision already in the law by which circuit courts can certify a case to the Supreme Court when they're not sure what the law is, often because the Supreme Court has issued pronouncements that are unintelligible or vague or whatever. The Supreme Court refuses to accept any of them. And in fact, not too long ago, in the last few months, there was a case certified to the Supreme Court, and it looked like there were very powerful reasons to think the court should accept the case for certification, but they didn't, and Justice Stevens and Justice Scalia dissented, saying, why in the world aren't we taking this? But they haven't taken one in many, many years. And one of our proposals is to require the Supreme Court to take at least half of its cases from the certifications from the circuit courts, and that would presumably and probably mean that they would give more attention to things like circuit splits, which reflect uncertainty in the lower courts, even if they're not very interesting cases about nude dancing or abortion or whatever.
There are lots of things to lose sleep over, but maybe one of those things that you don't need to lose a whole lot of sleep over is a circuit split. And I'll tell you why. Many of them are more apparent than real. When you get beneath the surface, a lot of times you find slight differences in fact or whatever that in some way explain or rationalize the opinions. And a lot of them work themselves out over time when someone's on the a circuit's on the short end of a 6-1 or a 4-1 circuit split. A lot of times the circuit will sort of cut back on its earlier precedent in order to move the law closer in with the majority of the circuits. And I think that to a degree the Supreme Court finds it useful to allow these things to simmer and develop, because then when the case finally reaches the Supreme Court, it has a dialogue before it and conflicting and contrasting points of view that probably aid in the disposition of the case. So I know that circuit splits worry people at a theoretical level, and if there was an area where they would be, where the impact would be detrimental, it would probably be in national business cases. But when I read the newspapers and everything about the things that business leaders and the rest are complaining about, I just don't ever pick up the Journal of the Washington Post and hear the head of this company or that company, Oh, it would be all right if we could just get rid of those circuit splits. And so, please, there are lots of things I lose sleep over and you lose sleep over, but please, not circuit splits. Yes, sir.
Philip Williamson, University of Virginia. Earlier said moving back to the justice are interesting. But I was curious about that phrase, civic virtue. What exactly do we mean by that, and what sort of civic virtue is trying to cultivate? Some of the changes that Jody wants to
I'll start. First thing we ought to perhaps try to distinguish is what's the historical concept of civic virtue. It's a compelling ideal for the framing generation, but it rests in part on some values as described in the portrait of Hamilton's portrait of the ideal judge that we wouldn't necessarily be inclined to endorse today. For one thing, they felt that in order to get virtuous participants in civic affairs, you needed to have people of wealth and social standing because they had the requisite independence not to be potentially corrupted. So I don't know that we would say as a criterion for membership in Congress we'd want to necessarily encourage those categories. So the term is kind of collapsed into a looser sense of we want honest, relatively incorruptible public servants, which of course would be a good thing. But the framers' conception is a much more elitist one.
All right, thank you, sir. Lee?
My question is, let's assume for the sake of argument that we can get past.
Could you speak up a little, please, Lee?
I'm sorry, I'm not sure what but let's assume for the sake of argument that we can get past the problem that different individual framers may have had different individual economic visions or theories or whatever they were, and which seems to have been a problem we've been running into when we're trying to figure out, for example, that Hamilton thought one thing and Madison thought differently, and they really did agree on some basic set of shared economic premises. What does that tell us about what the Constitution itself actually embodies? That is to say, for example, they probably assumed that the commerce power would be used to remove barriers to trade, not to impose barriers to trade. But is that what they wrote? And if that's not what they wrote, who cares what they assumed?
Jim, will you or Renee take that, please?
Well, I think, of course, that you can debate, how well we can establish the views of the framers as a group, and then, of course, we can also debate how much weight we should assign to that, even if we can't establish it. It does seem to me it's a helpful tool to understanding the commerce power. It does refer, incidentally, to commerce among the states. If we can establish to a fair degree of certainty that they envisioned a far more limited power than we have today, it seems to me could raise some serious questions about the extensive use of the commerce power in the post-New Deal period. The commerce power, it doesn't say Congress can regulate any little thing its heart desires, which is more or less what it's come to, right?
But that doesn't depend on their economic assumptions or their economic theories, right? That depends on what they wrote.
Well, but to understand what they wrote, we may find it useful to be guided by suggestions that they made at the time, which could at the very least be a key to what they had in mind.
I don't know what they had in mind. I mean, the same framers that put in the commerce power also put in the 10th Amendment. And the framers, the same framers that had a view of enumerated powers, and some say that's a restrictive view of enumerated powers, but they also included a necessary and proper clause. And so I look at the document, and honestly, I see so many tensions and so many arrows going so many different ways. A lot of times it's really hard to figure out economically.
Actually, the people who wrote the 10th Amendment were not exactly the same people who wrote the Commerce Power, because that was ratified some years later by a somewhat different body and drafted by a somewhat different process. But I'm not sure there's necessary tension here. The fact is that if commerce power is restricted to, in fact, trade among the states, then I think the 10th Amendment fits fairly harmoniously.
Yeah, I think that's right. And actually, with regard to the necessary and proper clause, Madison, when he became president, had some interesting things to say in veto messages about that. And he did say, and in a number of instances, he vetoed bills because he thought they were unconstitutional. They exceeded Congress's powers. And he does say that the necessary and proper clause has to be interpreted with regard to the limitations on Congress's powers.
How do you deal with the silent commerce clause then, which seems to envision an expansive role for the courts in striking down burdens on commerce that the states impose?
Well, if you view the Commerce Clause as, I guess there are a couple of things you can say about it. One, you can say in a certain sense it's harmonious with the idea behind the Commerce Clause, which was to strike down these restrictions on trade which the states were imposing. Another view is, that's a power given to Congress, and it should be left up to Congress. So you can sort of take that either way.
I could just very briefly, my view of the dormant commerce clause is that it doesn't exist.
Well, just to end on a disharmonious note, my view is it should be enforced more rigorously, and in fact, it embodies the very function that the commerce power was in fact originally intended to achieve: prevent the states from balkanizing the national market.
All right. Gene, did you have a question, or are you going to tell us all to go to the reception? Which?
No, that will come shortly, but I have a question.
All right, what's your question?
I wanted to, Professor Lund said something about, the question of whether the Constitution allows it or not. Rather, and I wanted to ask a sort of more general question of him if the Constitution, overall, he's confident that it's good, that it's a good thing. And I wanted to also ask on the civic virtue part. There's the famous Adams quote, which I'm going to mangle: "What the Constitution is suitable for moral and virtuous people, and indeed not suited for governments of any other." And I'm wondering what the panel thinks of that quote.
Nelson?
Could you just repeat the first question? I missed something in
The first question was, you were talking about the question of whether whether something is permitted by the Constitution or not. And I think in some people's minds, on some of these areas, there may be, maybe even if it's not the Constitution not being properly interpreted, maybe that's just as well, because something's become outdated or undesirable in the modern age.
Yes. Well, on the first question, I mean, that may be true. There's all kinds of illegal behavior by judges and others that may have good effects. I don't think people should break the law just because they think it will have some good effect. The better approach is to change the law if it needs to be changed. So that would be my view on that. But I agree that there's a lot of tolerance for lawlessness when people like the results. On the second question on civic virtue, I'm not going to talk about the general topic. I put it into my remarks because it's in the title of the panel, and I thought I should, and I limited my remarks to a particular kind of civic virtue, namely judicial virtue, about which I think the framers did have some pretty specific views, which they were assuming when they granted this extraordinary independence from any other political powers in a democratic society.
I want to thank everybody. I want to thank the members of the audience first. Each of the questions were excellent ones, and we appreciate them. And I also want to thank each of the four members of this panel for a very stimulating discussion and tell each of you how much I learned from listening to you. And thanks for being here, and I hope you'll all go to the reception and have a great deal of fun. It's great to have you.
That's the best part. Go to the reception. Yeah.